This wholesaler tried to screw me over by cutting me out of a deal last month. Look, if you've been wholesaling real estate for some time, this has probably happened to you, or at least somebody has tried. And if this hasn't happened to you yet, unfortunately, it most likely will. So in today's video, I'm going to show you how to protect yourself and prevent these wholesaling snakes from screwing you over. I'll show you the red flags that you need to look out for. I'll show you that despite my 14 years in the game, what I did wrong, even though I know better. Okay. I'm going to show you what I did to rectify the situation and still get paid so you know what to do if you are ever in this situation. So with that said, what's going on, guys? Mike Hill, the Wholesaling Titan here. And yeah, this guy tried to screw me. So let's jump right in and I'll give you a little bit of backstory. Also, just FYI, this was going to be kind of a hit piece. I was going to call the guy out by name and put his company out there. But at the end of the day, he did the right thing eventually. We did come to a resolution. So I'm not going to do that. I hope he learned his lesson, but even if he didn't, this is a really important lesson for you guys because, again, unfortunately, you will come across this. So this deal came to me from one of my students. On his end, he had a partner that he was working with who had a deal under contract with the seller. And he, meaning my student, reached out to me to see if I could find a buyer. Now, typically, I don't love when there are many different parties involved. However, I'm always going to look out for my students. And as long as there's transparency, communication, like whatever, I'm down. So I asked to jump on a call. I get both of them on the phone together. They break down the situation, and I asked to see the executed contract, which they send to me. Side note, I don't think my student did this on purpose, but their relationship was kind of misrepresented to me. It sounded like they had a good working relationship, maybe had done some deals together already, which is maybe why my guard was a little bit lower than it should have been. But I have to own that, and you'll see how this kind of plays out a little bit later. So, we come to a verbal agreement to split profits if I bring a buyer to the table. We got a buyer like 48 hours later, and I send a JV contract over that they both sign. Again, it's my student and the other wholesaler and myself. So three-way split. Now, if you are taking notes, the first thing I want you to understand is that the best way to protect yourself as a wholesaler is to take preventative measures. Now, I'm not saying you always want to assume the worst, but you need to be prepared for it. And the best way to do that is to make sure that your contracts are tight and that they cover, what happens in the event of a worst case scenario. So personally, I use Florida's state approved contract, the FAR, which is first off, legally recognized in Florida. It's drafted and updated to comply with state real estate laws, reduces the risk of disputes or unenforceable terms, covers contingencies, disclosures, buyer-seller protections, and it just gives you a more secure and professional transaction as opposed to, say, one of those generic 3-page wholesale contracts that you find online. And on top of that, even using the FAR, I still add additional terms dealing with things like, delays, extensions, permit issues, etc. So in this situation, the other wholesaler, he did use one of those generic contracts, which has kind of ambiguous language or maybe unclear terms. So we'll take a look at the signed contract here. Again, it's one of those 3-page contracts. Very, very simple. And we'll come back to this in just a bit, but that's it. 3 pages, your executed contract. But since this was already executed, the seller was very motivated. There was a buyer in place, closing is right around the corner. I'm not going to go ask the seller to sign a cancellation and re-sign a FAR. So I'm like, all right, cool. I'm just going to roll with it. Not everything in the business always happens perfectly. But also knowing this, right, there should have been kind of a blip on my radar. You're about to see why this was problematic, but just as an FYI, so often I see students or other wholesalers, or I get DMs or emails, and people get themselves into these sticky situations because their contracts are not written properly. As an example, I have a YouTube video about a situation early on in my career where my contract didn't specify who was responsible for open permits. And I learned this the hard way, right? That a permit issue is not an impediment to marketable title. And at the end of the day, I had to eat the cost of 10K out of my profit because neither the seller nor the buyer would concede. So tough lesson learned. So I get these questions from people that get themselves in these kinds of situations and they're like, Mike, what do I do now? And that's kind of like jumping out of an airplane without a parachute and saying, what do I do now? I mean, it's kind of too late. So most of the time when you encounter a problem or an issue like this, the mistake that you made usually happened like 3 or 4 steps back. And one of your best defenses is to make sure that your contract is specific, it accounts for potential problems, and it's just got to be ironclad. Now, if you want to see what I mean, I have an entire video on this where I walk you literally line by line how I fill out my contracts and the specific contingencies that I use. It's just one lesson inside of Wholesaling with Mike University. That program has over 20 hours of step-by-step instruction, as well as contracts, forms, calculators, and more. You can get access to my entire university for free. Just use the link in the description below, or you can go to wholesalingwithmike.com. So anyway, my buyer puts up a 5K deposit with the title company, contract, JV agreement, all the docs, they're submitted to the title company, and we start the title search. Closing is scheduled for like 2 or 3 weeks away. And during this time, and this is the next crucial part for my note takers, you have to stay informed on the deal. This is probably especially true when it's a JV deal. So that means you need to call the title company, find out who's in charge of your file, confirm receipt of all documents, talk to them, explain the situation, explain your role in the deal, build that rapport, keep in constant contact, ask for those updates. And also, you must ask for a copy of the preliminary HUD for you to review before the closing. All right. So look, a few days before the closing, I get this fun email. So again, the original agreement was signed, I think, for like October 2nd. They had a closing date of like October 16th. We got an addendum, extended it out to like, I think October 30th or so. And then on the 20th, I get an email from the escrow officer. Hey, good morning. It was brought to my attention that probate is needed for the deceased title holder. So unfortunately, we will need to push closing back as we wait on the probate process to be complete. Fun. So this is just a couple of days before we're supposed to close. And remember, I wasn't in contact with the seller on this. I simply didn't know the details, but I didn't do any work on this, and I understand these things happen. Now, if you haven't done many probate deals, you'll know that the courts can move notoriously slowly. So I'm prepared for a long wait, but I'm still staying involved, right? I asked the title company if the seller has an attorney, if they need a referral for an attorney, and I'm always, doing my best to assist in moving the deal forward. So they confirm that yes, the seller has an attorney, the seller still wants to sell, the buyer still wants to buy. So now we're just kind of playing the waiting game. Now, during this time, I'm regularly keeping in touch with the title company for updates, and you can also see the progression of the case in the public record. It's not some crazy huge deal. For me, it's kind of like a bonus deal, right? It just came out of nowhere. So maybe that's why I'm just a little bit lax on this one. But here's where we hit kind of some gray area and where I kind of mess things up, and also where those red flags come in. So the daughter who signed the sales agreement, remember the property was her mother's who had passed away. She obviously couldn't provide that marketable title that we needed to close by the original closing date due to the probate situation. So obviously, right, we couldn't close on the original closing date. And having marketable title is a contingency contractually of being able to sell. So usually that closing date gets extended until you have clean title, and the contract you use should explicitly state this, even if you have to write that into your additional terms, right? So you write something like, contract will automatically extend by X amount of time to provide free and clear title. Buyer and seller will do XYZ to rectify all issues. If it's not resolved by X date, buyer may cancel agreement and receive their deposit back, etc. So that's how you deal with that. But remember, using that generic contract, this was kind of alluded to. We'll look at the language in a bit. Like to me, it was assumed in the contract language, but I guess it wasn't stated overtly. So to be safe, I tell my student, hey, just have the other wholesaler. From now on, I'm just going to call this guy John, so I don't have to keep saying the other wholesaler. I'm going to say, have John talk to the seller and sign an extension just to make sure, right, as like a safety net, double check, just to ensure that we're protected and make sure that we're still in contract, right, that the contract is still valid. So my student gets back to me and says, yeah, sure, no problem. Later, he confirms that his partner, John, got the addendum signed and that he's going to send it to me. So at this point, I'm satisfied, right? I trust what my student says. We have a good relationship. I know the seller's motivated, and I mean, I don't know, right? I keep following up with the title company, checking the probate status, but I don't know, maybe I just forgot about checking to check to see that I received the extension. So some weeks go by, I'm still getting my updates, and I realize, oh wait, I don't have this extension. So I figured my student maybe forgot to send it to me, or maybe I lost it, maybe I deleted it, whatever. And I'm just like, hey man, can you shoot that over just to make sure we have everything? So then when he gets back to me, all of a sudden he's having trouble getting in touch with John. And as it turns out, they had decided to, yes, partner on this deal. And despite my student vouching for him, they aren't really partners, right? So more or less at this point, John is just ghosting him. So now to me, this is a red flag. So I skip trace the seller and I reach out to the seller directly. Now, normally in a JV agreement like this, I wouldn't do that. It's kind of frowned upon. It makes you look like you could be doing something shady, like maybe you're trying to steal the deal. And typically the way it would work is usually I would be the contact point with the buyer and the other wholesaler is the contact point for the seller. And then we're acting as middlemen. But yeah, at this point, I'm smelling like something isn't right. So I get in touch with the seller and I have to explain to her who I am, my role in the transaction and like what's happening with the transaction. She has no idea what's going on. Okay. John wasn't transparent about the assignment and she's just kind of in the dark. Then she asks me, she's like, oh, are you the guy that went to see the house a few days ago? And I explain, I am not, which is red flag number 2. This is not even a red flag, right? At this point, this is confirmation that John is now showing the property to additional buyers. So now I have to explain the process to her. I explain what we do as investors, that she's still going to get paid the same, that we are ready to close, and that, yeah, we're investors, like we're going to make some money off of this. But she's just kind of pissed that she was in the dark, but she relaxes a bit once she understands. And we actually end up building some great rapport, which is funny because by the end of this, she refuses to speak to the title company or John, and I'm the only one that she will communicate with to close the deal. But anyway, she proceeds to tell me that not too long ago, John reached out to her to say, hey, the original agreement that we had was not valid because of that closing date, we're out of contract. So he proceeds to tell her, hey, I'm just going to send over another contract just with a new closing date for you to sign. And she's like, yeah, sure, that's no problem. So yeah, she says, fine, no problem. She's an elderly lady and he sends it to her via electronic document signing service. And, you just click and she clicks and signs. So now he has a new contract that he's trying to actively market to another buyer and cut me and my student out completely. In addition, the purchase price that he had originally offered her, he lowered it on the new contract by $5,000 without telling her, hoping that she would just sign it. And that's actually what happened. She did. And she only realized that later on. And now she's really pissed. And that's super shady. You wonder why some wholesalers have a bad name. But anyway, or some wholesalers give all of us bad names. But anyway, I reach out to John to find out, hey man, like what the hell's going on? And surprise, surprise, he will not answer my calls. So I then reach out to the title company. I inform them of the situation and I make my case that the original contract is still valid because we're ready and willing and able to close, but we couldn't due to a title issue. And then again, there's some ambiguous language that still validates my claim in the original contract. We'll look at that in just a second, even though it's not crystal clear, which I like. Now, the processor here that I'm working with is not an attorney, but runs it up to his escrow manager, who then says, let's read this email here. Good afternoon, Mike. Our escrow manager reviewed the assignment contract, and they have confirmed that the assignment contract has expired by time due to there not being any extension signed. I recently called you. I'd be happy to speak to you over the phone if you like. Okay, great. So now I'm kind of mentally prepared to let it go. I'm not going to go crazy over one deal, and I believe in karma. But I'm like, all right, let me see what I can do. And I explained to my student what's happening. And he's really looking forward to and also counting on this deal, right? He's kind of in a tough financial situation. He's got a wife, he's got kids, got a sick parent. And he's asking me, Mike, man, this isn't right. Like, what can we do? How can we save this? And I don't have a guarantee. But I'm like, all right, let's see what we can do. And also, this is important, due to her frustration, the seller was actually willing to sign a contract with me and they say, hey, let's just go to another title company and close it elsewhere. The assumption that this first wholesaler probably doesn't have like any notice on it or whatever. But I'm not going to do that because one of these first two contracts, whether it's the original or the one that John had just signed, it's valid. And for me to do that, sign another one, that's just shady. Like I could get into legal issues. And more importantly, so it's so important to just operate ethically. If in that hypothetical situation, I had her sign a new contract and we did close it somewhere else, the seller would have to sign a seller's affidavit confirming that, listen, there aren't any other agreements that she's aware of, and that could be perjury. And now she would be in trouble. So that's just not an option. That I was unwilling to go that shady route, and that really should not be an option for you guys if anyone was thinking that. So here we are, right? The title company disagrees with me. I think they're wrong. But they do disclose to me, they tell me that John actually has another buyer and that buyer they did put up a deposit and they're going to be closing on the property in it's like 2 or 3 days. So despite it, I remember because it was Sunday, and despite being a Sunday where local notaries and banks are closed, I draft a memorandum stating that I have equitable interest in this deal. Then I jump online. I use a 24/7 online notary to get the document notarized via a Zoom call. Then I electronically file that memorandum with the county. And then next, I email the title company informing them that I have, in fact, filed this memorandum. So I'll show you this email here. I say, hey, hope all is well. First and foremost, I want to thank you for your communication, for your assistance on this purchase. Clearly, I'm quite disappointed in John. I think his actions are unethical and deceptive, but such is the nature of our business. It's not a reflection on you guys. That said, I have retained an attorney to review the situation, contracts, documentation, and applicable Florida law. On the advice of legal counsel, I'm formally confirming that my contract remains valid and enforceable, and I maintain an equitable interest in the property. As you are aware, earnest money was placed in escrow. I have remained ready, willing, and able to close since the original closing date, also evidenced by my continued and consistent follow-up asking for probate closing updates. Just days prior to the scheduled closing, we were informed that the property could not close due to probate issues. As such, we were unable to obtain clear and marketable title for transfer. Despite this delay being entirely outside of my control, your escrow manager has indicated that the existing contract is no longer valid. To protect my rights, I have filed a memorandum of purchase and sale agreement as well as a subsequent assignment claiming my equitable interest in the property. The document claim has been notarized and officially recorded with the Pasco County Clerk of Court. These filings place the public, including the seller and the title company, on notice that I hold an enforceable equitable interest in the property. So that's me putting them on notice. Then I go on to state some Florida law and contract precedent that support the continued validity of my agreement. So marketable title / probate delays. We have Rudin versus Pennsylvania, where title is unmarketable through no fault of the buyer. The buyer's obligations under a contract remain valid and closing is total until title is clear. Poe versus Savage, contracts do not lapse when delays in title clearance prevents closing, provided the buyer is ready and willing. Florida statutes 68902, blah, blah, blah. Recognize that a purchaser is entitled to rely on contracts contingent upon marketable insurable title. Then there's some contractual language, even in that first 3-page agreement that was signed, the original purchase and sales agreement, which again is a generic 3-page, and this is where it's a little bit gray area, ambiguous, but it does say seller agrees to extend at any point which may cause an impediment to the closing process. So this explicitly obligates the seller to extend the closing when the title issue prevent timely transfer. Seller authorizes the assigned title company to perform all necessary due diligence and to clear any title or insurance issues. So it reinforces that delays caused by property encumbrances are the seller's responsibilities, and encumbrance clauses and warranties regarding lien judgment and bankruptcies further obligate the seller to resolve issues and cannot negate the contract. Then I put evidence of performance and readiness. So the escrow money, the earnest money was in escrow. The inspection contingencies were satisfied, buyer available, and prepared to close immediately following probate completion. So per my legal counsel, in Florida, a real estate purchase contract is not terminated simply because the contractual closing date passes when the seller is unable to deliver a marketable title and the delay is through no fault of the buyer. Pending probate renders title unmarketable until the court admits the will and authorizes conveyance, meaning the seller is legally incapable of closing during that period. Under Florida law and standard title cure provisions in real estate contracts, closing date is therefore paused while the title defect exists, and the seller cannot declare the contract expired or the buyer in default based on a delay caused by the seller's own inability to convey clear insurable title. Given the above, the original contract remains binding and enforceable, and my equitable interest has publicly been recorded. Any attempt to close the property with another buyer would constitute a violation of my rights under Florida law and the recorded memorandum and assignment. Please confirm receipt of this notice and provide a date by which the title company and seller will honor the original contract and schedule closing, etc. I expect no steps will be taken to transfer the property to any other party while my interest is properly recorded with the clerk of court in Pasco County. Okay, so basically, I'm putting the title company on notice, and they won't, at this point now, they won't issue a title policy knowing that they could be on the hook. And so then I get this email. Good morning, Mike. As a neutral third party, Empower will not negotiate regarding this, and until a resolution has been made between you and John, we will not move forward with the closing. In order to move forward, once you guys come to an agreement, we will need in writing from all parties stating that we're authorized to move forward. Kindly ask that you reach out to John to discuss this. And lo and behold, wouldn't you know, the guy that was ghosting me, ghosting my student, get a call from him in like an hour, because this all happened probably like a day before he was going to close, or a couple days. So now he proceeds to give me the sob story, right? Tells me it wasn't his fault. He didn't know what was going on. He didn't do this. It was actually someone else in his office and they told him XYZ. And I just be quiet. I let him give me all the excuses. He doesn't know at this point that I've been speaking directly to the seller. So I let him talk his talk, and then I just shot him straight. I said, kind of called BS. I said, I told him I'd been speaking to the seller. She told me what you did. I'm not new to this game. And I told him straight up, I think what you did was wrong. I understand what you're trying to do here, but I'm not here to argue with you. I'm not starting any drama. I'm not here to place judgment. This is the situation we're in. This is what I've done, the steps that I've taken. Here are your options. Okay, let's see if we can find a resolution. We come to an agreement where he essentially agrees to pay me to withdraw that memorandum, and based on this guy's activity, I'm not going to take him at his word. So I agree, if we sign a new JV agreement, we can move forward, right? And he would have been, just FYI, fine splitting that with just me, but I'm not going to cut my student out. That would be super shady. So I insist on it being back to the three-way JV, and we bring my student back in. So back to the seller, she's not only upset about the situation, including that shady ass price reduction, but John had also agreed to pay her attorney fees for the probate stuff. And now he's claiming that it was just miscommunication. He never said that. She misunderstood, whatever. So, I mean, you got to do the business right. So she doesn't want to deal with him. She's increasingly skeptical about if this is going to close. She won't pick up his calls, won't talk to him, won't talk to the title company. Ultimately, she talks to me. I explain what she's getting, how everything works, what her options are. And then she's comfortable and we close. And at this point, this is largely due to just my transparency and also that rapport that we had built. And I'll tell you this, right? Just about every deal has its own unique challenges. And it is situations like this where amateurs lose deals. And I know this next part is lacking in humility, but I'm 100% confident that my student would have absolutely lost this deal had I not been involved. So with that said, if you are interested in one-on-one mentorship and doing some JV deals with me, click the link in the description for more details. I set up your entire AI-based marketing system, provide you leads, help you work them, get on calls with you, and then sell them to my buyers, right? Work the dispo. The goal is to get you your first deal in 6 weeks. I got plenty of testimonials. If you're interested, click the link in the description below. If you have questions, there's a link. You can book a free call with me. I'll answer those questions for you, give you more details. Although those spots are limited to a few per week. So if you're interested, make sure you jump on that ASAP. So look, I hope you guys understand that there are unfortunately some shady characters in the business, gives wholesaling a bad rap, but really that's every business. But you have to be prepared for these things. And I hope this video provided you with some key takeaways, awareness, knowing the importance of having tight contracts, writing those up properly. I want to encourage you to stay updated on every aspect of your deal, remind you to remain transparent and to be professional even when other parties are not. I hope you learned how to communicate with owners, partners, and title companies, and learned a tangible technique that you can use if you're ever in this situation, right? That e-filing, the memorandum. If you guys have any questions about this deal or any wholesaling questions in general, if you want more details on anything, please leave your comments and or questions down in the comment section below. We did end up closing on this, right? So HUD statement there. Also, let me know what topic you want to see me cover next. I don't know. Thank you so much for watching, and I guess I'll catch you in the next video. All right, peace.